1. The big picture. Most California family law cases settle, but sometimes a complete settlement just cannot be reached, and some or all of the family law issues have to go to trial and have to be decided by a judge. About 5% of the family law cases go to trial. At trial, the family law judge reads your trial brief, hears oral testimony, looks at supporting documents, and makes a ruling on the issues you cannot agree upon. This video deals with the trial brief you are required to file with the court that the family law judge will read before or during your family law trial. 2. What is a trial brief? A trial brief is a written summary to the family law judge explaining your position on the outstanding family law issues, as well as the legal arguments as to why the family law judge should rule in your favor. The trial brief states facts, evidence, and legal arguments that you plan to present at trial and normally includes citations to legal authority such as statutes or case law or rules to support your position. 3. County Superior Court trial brief format. Normally, each California County Superior Court has a required format for preparing a family law trial brief. Check online to see if your County Superior Court website offers the required trial brief format online. Most counties normally do. You can check in person with the clerk of the Superior Court where your family law case is taking place to see if the court offers a hard copy of the required trial brief format. 4. The headings of the trial brief. Generally, no matter the California county, the headings of the trial brief are roughly the same, namely 1. Statistical data. 2. Procedural summary of the case. 3. Settled issues. 4. Issues to be litigated at trial. 5. Proposal for resolution of issues and legal arguments to be relied on. 6. Summary of an expert report or testimony to be offered. 7. List of attachments and exhibits. 8. Other matters. And 9. List of witnesses. 5. Advantages of working up the trial brief. A trial brief has a positive effect of forcing you to work up your case in preparation for the trial. A trial brief forces you to do the following. 1. To identify the issues that need to be decided upon by the family law judge. 2. To research or double-check the law on the key issues you want the judge to rule on. 3. To identify who you will call as a witness at the time of trial. And 4. To identify the documents that support your position that you want the judge to rule on. 6. Exhibits. Attach to your trial brief the exhibits that support your case. Exhibits may include bank statements, appraisals of homes, title documents, etc. Attention! Getting exhibits into evidence requires that you comply with the California Rules of Evidence. If you are a self-represented litigant, the family law judge may be lenient in enforcing the California Rules of Evidence if the documents appear genuine. 7. Service on the other party. The trial brief must be served on the other party and filed with the court at least 5 court days prior to the trial. 8. When is the trial? The trial brief has to be generated before a trial. But when can you expect the trial? You will have plenty of notice of when the trial is coming. All California counties have either a mandatory settlement conference or a pretrial conference before the trial, or both. Only if the case does not settle will the court then schedule a pretrial conference. The purpose of the pretrial conference is to make sure that the parties are ready for the trial. The court will also use the pretrial conference to set up ground rules for the trial to include dates to exchange the trial exhibits or other documents. The family law judge will give you a trial date normally based on the estimate you and the other party give as the length of time the trial will take. This is known as the time estimate. You always want to estimate on the higher end because the judge gets very upset when you estimate a certain amount of hours or days and your trial goes a lot longer than the time you estimated. The more complex the issues going to trial, normally the longer the trial. Normally, complex issues have more witnesses that take longer on the witness stand and more documents. Normally, the longer the trial estimate, the longer the trial date will be pushed down the road on the court's calendar to accommodate the longer time estimate. 9. Seek legal help. Finances permitting, retain an attorney to help you prepare your trial brief. Some attorneys will help you prepare your trial brief on a flat fee or hourly basis. Finance permitting, you should also retain an attorney to represent you at the time of trial. California divorces involve having the family law judge hear the testimony of parties and witnesses and consider your trial brief and other supporting documents. Whether certain testimony or documents are proper, relevant, or admissible for the family law judge to consider depends on a lot of legal rules. The legal rules are as follows. Tier 1 rules include the Family Law Code, 2, the Code of Civil Procedure, and the California Code of Evidence. The second tier rules are the California Rules of Court. The third tier rules are local Superior Court rules. And last, sometimes a family law judge may have his or her own department rules. A competent family law attorney will help you navigate all these rules. Takeaways. The trial brief is a summary of facts, evidence, and legal arguments that you plan to present at trial to the family law judge to support your position so the judge rules in your favor.